So the last case to deal with this topic occurred in 1986, and we don't get there again questioning sodomy laws until 2003. So a significant amount of time has passed. There's been significant overturn on the court, and the decision of the court is very different. So the background of the case, um, Texas law prohibited sodomy between individuals of the same sex, and they defined sodomy not in in an interesting fashion. It was defined as both oral or anal sex, so pretty much they were outlawing same-sex contact of all types for the most part. And such activities were clearly not prohibited by individuals, opposite sex couples. Um, the police entered Lawrence's home, having heard reports of weapon disturbances and observed the men having sex. Um, Pretty much the same sort of setup as you get in Bowers v. Hardwick. As an interesting side note, in this particular case, the neighbor who filed the weapons disturbance complaint was later convicted of having filed a false police report, and one need not imagine why an individual would do that. This individual was very clearly trying to interrupt the consensual activity which was going on next door. So the men who were adults at the time both attended that their conduct was private and consensual, and the issue comes before the court again. It is very much the same issue in Bowers v. Hardwick about whether this law violates notions of the right to privacy, and the court says, well, very clearly, yes, it does. Justice Kennedy writes the opinion in this case. Justice Kennedy, while on the court, wrote the majority opinion for every decision that involved gay rights. And they all went in a liberal direction. This is one of the first cases that he writes. And so I'm going to read the first paragraph of the case because it's very clear that, at least for Justice Kennedy, this is an exceedingly important issue. He writes, "Liberty protects the person from unwanted government intrusions into a dwelling or other private residence. In our tradition, the state is not omnipresent in the home, and there are other spheres of our lives and existence outside of the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. This instant case involves liberty of the person both in its spatial and more transcendent dimensions." Clearly signaling that privacy is going to play a role. And Kennedy is pretty decisive in this area. So there exist three sort of issues before the court. And the first, does the law violate vital interests in liberty and privacy protected by the due process amendment, or due process portion of the 14th Amendment? Does the law violate the equal protection clause of the 14th Amendment? And should Bowers v. Hardwick be overturned? The court says yes to all. So yes, the law violates the 14th Amendment due process clause, which means functionally there is a substantive due process right to engage in homosexual behavior in the privacy of one's home. So significant portion of the decision. Furthermore, does the law violate the Equal Protection Clause? The answer is, the court gives is yes, because same-sex couples are criminalized in a way that opposite-sex couples aren't. That seems to be the easiest equal protection violation that the court has dealt with. And then they overturn Bowers v. Hardwick. Laws prohibiting sodomy, says Kennedy, do not seem to have been enforced against consenting adults acting in private. A substantial number of sodomy prosecutions and convictions for which there are surviving records were for predatory acts against those who could not or did not consent, as is the case with a minor or a victim of assault. But far from possessing ancient roots, hearkening back to the argument in Bowers, American laws targeting same-sex couples did not develop until the last third of the 20th century. So Kennedy simply states that the laws, the way in which sodomy was used, sodomy laws were used, were to target instances of rape and assault. They weren't used to target consenting activity until the laws very clearly began to target just same-sex couples, and that didn't occur really until the large half of the 20th century. And in fact, if you look specifically at the laws, which Kennedy does go through in some extent, it wasn't until the 1970s that states began only to criminalize homosexual activity, and only 9 states in the totality ever did so. Of the states, only 4 states continued to ban only homosexual activity, Texas obviously being one amongst them. And of the 25 states that at the time this case took place banned sodomy, they did so to both couples, or to both same-sex couples and differently sexed couples. So, in summary, the historical foundations that Bowers sort of built itself on are absolutely overstated. And so the court sides in this case very clearly on the notion of privacy, and that there exists privacy within the confines of a marital bedroom, but that privacy extends further. And Kennedy sort of touches on this. He argues that there exists a stigma to this criminal statute, and that stigma is not trivial, in that an individual charged with this crime has to, in the state of Texas and elsewhere, register as a sex offender because they violated a sexually based law. And that creates a stigma that resonates in ways that clearly make this even more unconstitutional, and that there very clearly exists a due process protection for this activity. Kennedy says that petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. And so, for the first time, and it takes until 2003 for it to actually happen, the court says that your personal liberty, your privacy interests include private consensual sexual activities is a protection of all adults in your home. Is not just for married couples, is not just for differently sexed couples, but sexual activity in the home is protected. All sexual activity, as long as consensual, is protected. The court doesn't deal a lot with the Equal Protection Clause, because once you've overturned a law for one reason, the Due Process Clause, the Equal Protection Clause really isn't necessary. But Justice O'Connor concurs, and she does articulate a very different argument. And she was part of the majority decision in Bowers. She was one of the 5 justices that voted to uphold the constitutionality of the law in Bowers. In this case, she concurs with the judgment in this case, but she provides different reasoning. She says that the Bowers case should not be overturned, but the Texas law should be unconstitutional solely based upon the Equal Protection Clause. So she doesn't want to weigh in on the Due Process Clause. She wants to weigh in solely on the Equal Protection Clause. And so her argument is that Texas treats the same exact conduct differently based upon the sex of participants. That's a violation of equal protection. She says a law branding one class of persons as criminal solely based upon the state's moral disapproving of that class and the conduct associated with that class, one's contrary to the values of the Constitution and the Equal Protection Clause under any standard of review. So she doesn't even say that it's rational basis or it's strict scrutiny. She says any standard of review, if you're treating one class of people differently than another class of people based solely upon their identity, that's a violation of the Equal Protection Clause. So she is the sixth vote in this case that agrees in the outcome, but disagrees with the decision. So she would not overturn Bowers. She would not say that there exists a substantive due right to privacy for homosexual activity, but she does still vote with the majority because they side against the state of Texas. But her vote is not necessary because she was the sixth vote. There exists 5 individuals that do agree that there exists a substantive due process privacy right and that Bowers v. Hardwick should be overturned. Justice Scalia dissents with Justice Rehnquist and Justice Thomas joining him. He argues that homosexual sodomy is simply not a fundamental right, but the only way in which substantive due process can incorporate a right is by identifying it as a fundamental right. That's problematic. The Texas law, he argues, is a restraint on liberty, no question there, but there are many such examples of restraints upon liberty in the United States. Laws prohibiting prostitution, laws against the use of heroin, laws against a 60-hour work week. But since there is no fundamental right to any of those activities, the state can take away someone's liberty as long as there exists due process of the law, which there was because the state properly passed this law regulating sodomy in this case. So his argument is that he doesn't accept simply that there exists a substantive due process right to homosexual activity. You have to buy into that portion to agree with the rest of his argument. And this is really the problem with substantive due process rights. You have to agree that such a right exists in order to read it into the Constitution. In this case, clearly 5 individuals on the court did. 4 didn't. And you change one person on that, and it goes in an entirely different direction. And the decision of whether a right is fundamental or not is very clearly an ideological one. And so while one can critique Scalia's viewpoint on homosexuality or on homosexual behavior, it's really more difficult to critique his view of substantive due process, in which he's very clearly arguing that, look, substantive due process, you read this right into the Constitution, you say it's fundamental. But there's 4 judges on the court who's saying, no, that's not a fundamental right. And that's not a small minority. It's not one judge disagreeing. This isn't like Griswold. This isn't like other areas where it was an overwhelming majority of the court that says this is a substantive due process fundamental right. This is a very sharply divided court that is making that argument. And there has to be some level of agreement that a substantive due process right, a fundamental right exists before we can move forward. But in this case, the majority, a very slim majority, a 5-4 majority, identifies that there is a fundamental right and therefore rewrites the Constitution in one fell swoop in a way that seems almost too easy. Questions?